Good morning, Your Honor. I'd like to reserve 5 minutes for rebuttal.
Yeah.
I may please the court. I'm Lindsay Lopez on behalf of the appellant Ethan Levy, and we're asking the court to reverse 2 Board of Medicine orders denying Mr. Levy's petitions to remove restrictions on his Florida physician assistant license. He did. Yes, you're right. There was a settlement agreement. There was a settlement agreement. And
Was there any requirement that
there's a requirement that the board consider whether or not there's been a substantial change in circumstances and whether there's a demonstrated public need or public interest.
you think that was fulfilled?
I don't believe that was fulfilled. I think if you look at the comments, first of all, the 2 orders denying his petitions to remove the restrictions don't contain any discussion of the reasons that the petitions were denied. And so under the case law of Alachua County and the Mann case that we've cited, the orders should apprise the petitioner of the reasons for the denial. But even though the orders don't contain the reasons for the denial, the board's comments at the 2 hearings are very clear that they sort of applied a blanket policy that said, this is a final order. We don't ever want to revisit final orders. It wouldn't be appropriate to revisit final orders because we're afraid that may open up the floodgates and people may come in here asking us to look at these things again.
Well, let's get the lay of the land. You don't disagree that this is a board of qualified physicians, right?
That's correct, Your Honor.
So it's a board of qualified physicians reviewing a restriction on a physician assistant.
Correct, Your Honor.
Granted, you have a client who seems to be a very good physician assistant, but was charged with a felony. Reduced it to a misdemeanor. He pled 2 years community control. He got a restriction on that license, and that's for dispensing opioids. And then he goes to laser spine, and he's working with patients that are on opioids. He's not prescribing, but he's working with patients on opioids. LSI goes belly up, poor business in Texas. He comes to Florida, does the same thing. LSI, terrible lawsuit, awful business practices. Unfortunately, for fine, he's out. But he's dealing with pain of patients. And I kind of take issue with the fact that you told the Florida board that he wasn't represented. He was represented when he executed the settlement agreement. I'll show you that. He executed the settlement agreement January 17, 2014, and he was represented by the electric firm in Austin, Texas.
He was represented in connection with the
Right. When he agreed to the settlement agreement to paragraph 6. And then in March 14, 2014, Mr. Dest of the electric firm files a motion to waive his appearance before the Florida board. There's no dispute about the settlement agreement he signed. There's no indication he disagrees with it. He didn't even want to show up. So you waive his appearance. It's only when he shows up that he's by himself. So I just kind of get the lay of the land. It's not like he sat down with a bunch of board certified physicians or the lawyer right here and was coerced into agreeing not to do what he agreed to do, correct?
That's correct, Your Honor.
Okay, let's start there. Go ahead.
He voluntarily entered into the settlement agreement, but after the time that he entered into the settlement agreement, there were 2 substantial changes in circumstance. One is that the sole basis for the Florida administrative complaint against him. And so he didn't really have a great basis to contest.
Well, his lawyer in Texas put anything in the Florida board order referencing if something happens to the Texas order, it will trigger something in Florida.
No, and I will just.
Okay, yes or no?
No.
Okay.
But I will just state for the record that the Texas lawyer was not representing him in connection with the Florida proceeding.
So you're telling me that despite the fact that we represent Mr. Levy, we want to waive his appearance in March, 2 months after he executes the settlement agreement, he's not counseled?
That's correct, Your Honor.
How is that so?
Your Honor, he was not represented in connection with the negotiation of the Florida order. And
How is that possible, man? The record shows that he was.
I'll just
Are we
represent.
supposed to rely on your representation? Because you don't have anything in the record showing that he wasn't. And that's what concerns me, because Your first contact with the Florida board is you're telling them that he's ignorant of the law, basically was railroaded, and he didn't understand what he was doing. And that for judges means a lot to us, because we reverse cases when that really does happen. But what I'm saying to you is from this record, it doesn't appear that that happened at all.
I understand, Your Honor. I'll just represent to you that he wasn't represented. He didn't have a lawyer assisting him with the negotiations.
That's your argument.
Okay, I understand, Your Honor, but even if he had been represented at the time that he entered into the Florida order, the Florida settlement agreement, he didn't have there was a good basis for the Florida restrictions at the time he entered into the settlement agreement, because his license was disciplined in Texas. And so going through the process of having an administrative hearing and the expense and cost of that, he wasn't likely to prevail at that time because there were restrictions on his Texas license, and under the Florida statute, the Florida complaint against him was based exclusively on the Texas discipline, but that on its face would have been enough to have the restrictions in Florida. And so the fact that the Texas restrictions were removed from his Texas license is a substantial change in circumstances.
Okay, so are you going to argue to us the fact that he told before the board, I will never practice in Texas again, is insignificant and immaterial, and had nothing to do with their decision to remove the restriction?
He told the Florida board that he would
No,
never.
it's all the Texas board. I'm not coming back. I'm not coming back to your state to practice.
Well, I think the Texas board, when they discussed that in their order removing the restrictions, they discussed it in the context of the fact that there were some 8 cycles that he was supposed to do with chart monitoring, and because he was practicing out of state, he wasn't able to complete. He only was able to complete 3 of those cycles. But there's nothing in the Texas order that suggests that the reason that they removed the restrictions was because he wasn't planning to practice in Texas.
Well, I thought enough of it to include it within the body of the order that he said he's not coming back.
They did, in connection with the statement about what the reason that he didn't complete the 8 cycles of the chart monitoring. They didn't say we're removing this restriction because he's not going to practice here again. Instead, they talked about the fact that he completed most of the requirements of the restrictions in Texas, and the fact that he appeared to be contrite, he appeared to be sincere. They considered, it looks like, all of the letters that were submitted from colleagues who had worked with him, who all gave information about Mr. Levy's real dedication to opioid education, opioid sparing programs, creating programs to try and do opioid sparing, and that he really learned a lot, was very sincere and contrite, and had no problems in the intervening years. Even though he was working with patients with opioids, there was no problem. There was no problems in the intervening years with Mr. Levy as a practitioner. And so there are 2 significant changes in circumstances following Mr. Levy agreeing to the Florida order and the entry of the Florida order. One is what we talked about, which is all the restrictions were removed from his Texas license. And I understand the board's position is that the disciplinary guidelines in the administrative code don't apply because this was a settlement agreement. But if this had gone to a final administrative hearing and they had imposed restrictions on his license, those restrictions could not have lasted any longer than the length of time that there were restrictions that his license was encumbered in Texas. That's under the administrative rules that we've cited, 64B 30.0152. So that's the extent of what the board could have done after a final administrative hearing. And so even if those disciplinary guidelines do not strictly apply to settlement agreements, it is clearly evidence that there was a substantial change in circumstances, that the discipline that was imposed against him was more significant than what the board could have gotten if they had gone through a final administrative hearing.
What about the reason he was disciplined for prescribing opioids without doing examinations, diagnostic studies, and all of that? Isn't that a factor that these qualified physicians in Florida can consider?
Absolutely it is,
Okay,
but there's no evidence that
Aren't
they,
we dancing around?
well, there's no evidence that they did consider it. The evidence is that they came in and said,
Well, wait a second, if their ultimate decision, and I got it in the transcript, if you need me to read it, was for the protection of the public. What are they protecting the public from if it's not from someone who may have made a mistake, but made a mistake by dispensing opioids in contravention of certain guidelines?
well, I think that the evidence, if you look at the Texas order and even the Florida order that follows, there were a number of mitigating circumstances involving the original discipline against Mr. Levy's license in Texas, that he worked there for a very short period of time.
But he also testified against his supervising physician.
He did.
Charged with felony. We don't know what happened, but I'm certain it's a felony because it's trafficking and criminal. So I don't know what it is medically. But he agreed to testify. We don't know anything else about that. And in his agreement in exchange for that, it was reduced to a misdemeanor. It's still a crime. And it's
Yes,
2 years of community control.
Right, but there were a number of mitigating factors and there was no evidence of any problems following that. The only reason for the discipline in Florida was the fact that there was discipline in Texas.
Well,
And
but
when
the law requires that, right?
Yes, Your Honor.
And to your client's credit, his lawyer immediately wrote to the Florida Board of Medicine and started the process.
Absolutely. He followed after he went through the process in Texas. He took it very seriously. He was very serious about fulfilling all the requirements and doing everything he needed to do because he's a very dedicated, very highly qualified, highly skilled practitioner, and he completely followed the requirements of what he was supposed to do. And if you look at the record, the statements from the board members here, we have Mr. Telechia, who was the Chief Assistant Attorney General there, saying it would be highly inappropriate to go back now and remove a restriction that was in a final order. You have Dr. Zachariah stating that we cannot change what was signed in the settlement agreement under any circumstances because you open a Pandora's box.
Was that the June 2021 hearing?
That was from the June 20. The
What
June.
about October 2021 hearing? Rehearing, Dr. Zachariah said, and I quote, "What is so special or unusual about your case that we should grant your termination?" And his client's answer was, "I'm an extraordinarily dedicated healthcare provider asking you to take a leap of faith and to do the same for me that Texas did."
Yes, Your Honor, but you also see Dr. Zachariah's statements in that same transcript that says, you see, the concern that I have is that everybody has an excuse as to why they're terminated and you cannot get into that. He's saying we can't look at it. There's a policy here that we're just not going to look at final orders again because we don't want people coming back in here and asking for these things to be revisited. And the problem is, first of all, to the extent that they're concerned about creating precedent, that precedent already exists. We cited a couple of the administrative cases and they're in the supplemental record. There's Dr. Malik and there's Dr. Pierre. Dr. Pierre's case is particularly kind of interesting in this particular case. Dr. Pierre's discipline was for reasons that were similar to Mr. Levy's. It was the fact that he was engaging in telemedicine and prescribing all sorts of controlled substances without doing physical examinations. He was just doing it based on online
So
questioning.
was that a crime? Was he charged with a crime?
He wasn't charged with a crime.
Okay, well, the distinction in that case seems to be that the scope of telemedicine is kind of new. And the law changed. And the interim it changed. And that was a change in circumstances because of the change in the law, correct?
It was a change in circumstances, but it wasn't a change in circumstances, I would argue, as significant as Mr. Levy's. First of all, there was no reason that Dr. Pierre couldn't continue doing all kinds of practice outside of telemedicine. Whereas with Mr. Levy, what he's dealing with is an increased reluctance or increased issues with insurers credentialing him at all. So what Dr. Diamond says is this was intended to be a very specific, very concrete, very
I
limited.
just want to interrupt to remind you, you're down to about 5 minutes and 40 seconds. Do you want to save you 5 minutes and use 40 seconds to finish?
I'll finish up here and then reserve my time. And that Dr. Pierre, I lost my train of thought, but in the circumstance with Dr. Pierre, the settlement agreement he entered into did not include a permanent restriction. It was proposed to be a temporary restriction. And when the board approved it, they went back in and said, we're not going to approve the settlement agreement as is. It's important to us that this be a permanent restriction because the issues with his prescribing on telemedicine were sufficiently serious to the board But then appropriately, when he came back in and said the scope of medicine has changed, this is preventing me from doing much more than what we intended to do at the time.
Give you 5 minutes, you keep going, say what you want.
Thank you very much. I'm just going to wrap up right here. The board appropriately considered that the consequences of agreeing to the restriction on telemedicine were much broader than was originally intended. It was impacting him in a much broader way. And that's the same situation with Mr. Levy. He is fine with the restriction of not working in pain medicine, except that it's interfering with his ability to practice at all. He doesn't want to work in a pain management practice again. He's not able to practice really at all outside of a cash only basis because he can't get credential from any of the insurance companies. And that's not what the board intended. And that's a significant change in circumstances.
Okay, you got 4 minutes and 15 seconds. I'll favor for your vote.
May it please the court, my name is Marlene Stern. I'm with the Attorney General's office. I'm representing the Board of Medicine. I'd just like to pick up
I'm having
on,
a problem with the audio. You lower that mic a little bit?
Okay.
Let's try it.
how's that?
Can you stand closer to the mic?
How's that?
Good. Close. Thank you.
I just want to pick up on that Pierre case. Because I think it's distinguishable from the case at bar here. Dr. Pierre did have a permanent restriction on his license. He was living, I think, in the Dominican Republic. He had a Florida license. He was dispensing scheduled drugs, diet pills that were somewhat addictive, and doing it only by electronic transfer of information and no physical examination. That was illegal at the time. He was disciplined. A couple of years later, telehealth rules changed so that you could conduct telehealth strictly by transfer of electronic information, and you did not need a physical exam. So what in effect happened was what he had done that was illegal was made legal.
Can I ask you one question? I want to ask her, but I don't want to interrupt her flow. What's the standard review in this case? Is it abuse of discretion?
Yes.
Or is it proving modified circumstances that are unrefuted in the record?
Well, in my cases that I cite in the standard of review section, those cases say that when a board is looking at changed circumstances, it's an abuse of discretion standard. So I say that the standard of review here is whether the board used its discretion in determining that there were changed circumstances. And that really is the question for the court today. I think that, did the board abuse its discretion by denying the requests for the appellant?
We reverse it for a new hearing or simply to grant relief requested?
I would ask you to affirm the order.
I said if, I used the word if.
Oh, okay.
Take on that. If we were to reverse it, are we reversing it for a new hearing or for the board to grant relief requested? If.
Well, I think what that depends on what I gather from what the appellant wants is you would reverse and remand for the board to reconsider whether there were changed circumstances.
She was arguing they applied the incorrect standard, among other issues. So if it was the incorrect standard, we reverse it for them to apply the correct standard.
Yeah, I think what she was arguing is that the board was applying and I had a hard time with this argument at first too. I think what she was arguing is that the board didn't apply the correct standard. She wasn't referring to standard of review, which is initially what I thought, but she was referring to the standard that that there are changed circumstances and you have to look at the changed circumstances. And that's the standard she was talking about, not a standard. Again,
Did the Florida board inquire about the change in circumstances?
the Florida board knew when it walked in there, everything in the record was given to the board 2 to 3 weeks in advance. The board definitely considered whether there were changed circumstances. They got the materials in advance.
What she's talking about, because the June hearing seems to be kind of a short hearing.
Well,
But he's granted a rehearing.
mhm.
And Dr. Zachariah asked that specific question. and tell me what error did they make that would require us to reverse? If they've asked them about the situation, they appreciate the circumstances, they appreciate the severity of the offense with which you charged them. They know its history.
Mhm.
What did they miss?
I don't think the board made an error, if that's what is that what you're asking?
Yeah.
No, I don't think the board made an error. I think that when it walked into those meetings, it knew exactly what the issues were. And I think what's happening is that the appellant is making presumptions about the board members' thought processes, which they aren't entitled to make. Right, it's a number of board members didn't even speak. So you can't presume they didn't consider the materials they were given, or that they didn't consider what the appellant's attorney said at the hearing, or what the appellant said at the hearings. They had all of these things to consider. What they chose to address is a different story. It doesn't mean they didn't consider everything.
And you've argued that Florida statute 1.57 does not apply to civil agreements, not credit counsel, that she seems to agree with that. Tell me why it doesn't apply. It doesn't seem that the plain language of that statute indicates that it doesn't apply to substance.
Well, there is a sort of preface paragraph before you get into all the disciplinary guidelines. The disciplinary guidelines are in a table. And in front of that is an actual paragraph. It's not in a table. And it says, and I quoted in my brief, that the disciplinary guidelines apply to proceedings conducted under section 120.571 and 120.572. And those are respectively formal hearings and informal hearings. Settlement agreements are conducted under section 120.574. So it doesn't say that the disciplinary guidelines apply to proceedings conducted under 120.574. And that's why we argue that the disciplinary guidelines, the settlement agreement does not have to follow the disciplinary guidelines.
In the settlement agreement, there's a paragraph that says respondent agrees that the stipulated disposition in this case is fair, appropriate, and acceptable to respondent. What weight is that carrying?
Well, that carries a lot of weight because the settlement agreement was entered into between the appellant and the Department of Health. And this is something that the appellant entered into voluntarily.
It seems pleased with it based on the word.
Right. And in fact, the settlement agreement had more things in it than the board actually removed some of the discipline that was in the settlement agreement. Removed probation, it removed the requirement to take a drug class. So it's the appellant got the benefit of his bargain. He willingly signed the settlement agreement. Now he's trying to unwind the agreement. But what I'd like to get back to just briefly is that there has been no abuse of discretion because there have been no changed circumstances relevant that are material to Florida. With respect to the Texas agreement, the Texas order, that order had a provision that said these conditions can be changed, but you have to wait a year to change them. Okay, so the restriction could be lifted, probation provisions could be lifted as long as he waited a year. The order envisioned that. The order included mitigating circumstances. The board's order had none of that. The board's order said this is permanent. The board did not recognize any mitigating circumstances or anything. So the fact that it was lifted in some of the restrictions were lifted in Texas, and as you said, Judge, they considered the fact that he was not going to practice in Texas anymore. The structure of the Texas order is not like the structure of the board's order. And the fact that the restriction was lifted in Texas isn't material to the Florida order because it just didn't contain any provisions whereby he could get out of the restrictions on his license. It didn't envision that he would get out of this permanent restriction, whereas the Texas order did. And so there's not a material change circumstance there from the perspective of the Florida Board of Medicine with respect to the Florida order.
Good question. One of the circumstances, other than TRICARE, we have in the record, what other carrier, and many, have denied him?
Well, that gets to, the second alleged change circumstance. There's nothing, what it is the assertions of the attorney saying, just coincidentally, when the board issued this order, it's a theory that this, TRICARE denied his insurance just after the board issued its order, and that started an industry-wide trend. And because of that industry-wide trend, the appellant hasn't been able to practice anywhere except, well, he does have a job in healthcare, but he hasn't been able to practice in a traditional practice, which is where he wants to practice. But there's no evidence that he ever applied anywhere else. There's no denials of anything else. This is purely based on evidence, a theory of, putting things together, what little evidence there is together and creating a story. But I think the record equally supports the thought that a story that this process was in effect, it predated, this trend predated the settlement agreements and was just applied and become in force. I think.
And one last question concerning legal significance, paragraph 10 of the settlement agreement, whereby the respondent expressly waives all further procedural steps and expressly waives all rights to seek judicial review of or to otherwise challenge or contest the validity of the agreement and the final order of the board incorporating said agreement. I haven't heard anyone argue that. Did he in essence waive this? Did he waive a challenge?
Well, I don't think.
Gotta mean something.
Yeah, I think that provision is in there because they don't, he can't pursue, we can't issue the appeal and then have him say, no, I'm going to appeal. We can't issue the settlement agreement and no, now you can't appeal the settlement agreement. That's how I've seen it applied, but I do take your point. I think it's a very good point that it could apply in a situation like this. It's just not been applied in a situation like this. But I want to get back to the TRICARE situation, which is an alleged change circumstance. The only thing that we have in the record is that we have a denial by TRICARE. It happened 9 years ago now. It's not a change circumstance anymore. It's just the status quo. And finally, the other argument is that the order should be reversed and remanded because it would serve the public good. And that argument is based on emergency orders issued during the height of the COVID-19 pandemic, which tried to fast track the admission of out-of-state practitioners into Florida because there's a need for more healthcare providers in Florida. But the problem is it didn't apply to practitioners whose licenses were encumbered. His license was encumbered, and in any case, he has been working in the healthcare field. So at best, maybe he would change the kind of healthcare setting he worked in, but he was a practitioner in Florida in healthcare at that time, and it wouldn't have added a new person. It might have just changed where this person worked. So I don't think any of the changed circumstances, the alleged changed circumstances, are either material or changed or relevant. Texas order is not material because the Florida order did not structure like the Texas order. TRICARE, the TRICARE situation, the evidence doesn't support the theory that there's a industry-wide trend now where he can't get insurance anywhere because it doesn't show that he can't get insurance. And finally, the fact that removing the practice restriction will serve the public interest is also not correct because he's already practicing in the healthcare field. So There are no further questions.
Hey, I know I encroached on some of my time, so I'll move as quickly as I can. I wanted to address your first question about the standard of review. I agree that if the board considered changed circumstance and whether their determination about whether or not there was a changed circumstance, that's an abuse of discretion standard. And I do think our argument is that the board did abuse its discretion here, because we think there were the change to the Texas order in particular is a very significant change in circumstance. But I think the Galvin case that we cited has a really good discussion of the relevant standards of review. And the question of what standard to apply when looking at this petition to modify is a question of law. And in looking at that, it would be a question of law as to whether or not they were allowed to make a blanket determination that they're never going to look at final orders again, or whether or not they are required to look at changed circumstance and demonstrated public need. And our position under the Mann case is especially instructive on this, is that they are required to consider it. They are not allowed to have a policy that says we are never revisiting final orders. And Mann talks about that extensively. And also it talks about the fact that to the extent that the argument is that the board did consider all of this and found that there were not sufficient circumstances to justify the modification, it's not clear from the orders. The orders just say denied. And so the Mann case says, alternatively, if the board's order constituted a summary denial of the petition because it contained insufficient facts to justify modification, the order does not apprise the petitioner or this court sufficiently as to the reason the petition was defective, and so it's remanded for further proceedings. And so my argument is that this should be reversed and the restrictions should be removed, because the finding that there was no change in circumstance is not supported by substantial competent evidence. But alternatively, at a minimum, it needs to be remanded for further proceedings for them to consider whether or not there was a change in circumstance. And the situation in Mann is really interesting on this, because when it was remanded, we cited the later administrative hearing decision in Mann. It reflects that when they went back and looked at it again, when they weren't just applying a determination that we never look at these things again because we don't think we have jurisdiction or we don't want to do that, they did remove the restrictions on this license. So we do believe there's good cause to believe that if the board was told, you need to consider whether or not there's been a substantial change in circumstances. You can't just say we're not revisiting final orders, that when they look at the particular circumstances of Mr. Levy's case, they're going to find that there is a big significant change in circumstances. And I will just
The change in the Texas order is the strongest argument.
I'm sorry.
The change in the Texas order is that your strongest argument.
I think it is. I think it's a really important argument because it was the sole basis for the Florida discipline. There were no other reasons cited in the administrative complaint against him. And the relief that was granted against him in the settlement agreement is broader than the court, or not the court, than the board could have applied if he had gone to final hearing. So I do agree that on its base, those disciplinary guidelines do not apply to settlement agreements, but it is clearly a substantial change in circumstances. It's a very important change in circumstance. I know there was a question about whether the other important change in circumstance, though, is the fact that he is having really an inability to get any employment at any non-cash, any place that requires insurance. It's very significant for Mr. Levy because he's a physician assistant. So he has to practice under a physician. So he can't just say, well, I'll go out on my own and I'll just do a cash only practice. He has to find somebody who he can do that under. So it's a very significant restriction for him. I know that there was a question about whether there was evidence in the record to support the denials. We have Mr. Levy's statement that was attached to the renewed petition. And that sets forth the fact that he was unemployed for a year looking for any employment. The only employment he's been able to find is at this holistic practice. And it has to do with his inability to get credentials. It's not as robust as you would want for the evidence after a court hearing, but the sort of the nature of the administrative proceedings is sort of reflected in the Delray Beach case, is that they're often summary. They're often, situations where people are proceeding on proffers and those sorts of cases. So there is evidence in the record to support that. And the only other thing I wanted to clarify is he was not granted rehearing on his petition. He filed a renewed petition and came in because his petition originally was just denied. So he filed a renewed petition and it added additional factors about changed circumstances and additional kind of fleshed out the factual situation. It was a renewed petition. It was also denied, but he was not granted rehearing by the court. They just denied the first petition.
You're technically out of time, and I let you go to 5 minutes.
Okay.
So you're technically more on the.
Thank you very much.
All right, have a great day. Thank you. We're gonna move on to the next case on the docket, which has been printed out in the things. And that's gonna be Marshall versus Hannon.